Hello, folks. My name is Jim Worthen. The show is Worthen One. We're here on Channel 17 on the Cox Cable on the south coast of Santa Barbara County every weekday at 2 o'clock at Friday, and then Friday night at 7. But we're going out on two cable outlets. One is TVSB's website, and the other is YouTube. And the reason for that is obviously the things my guests talk about and I talk about are worldly, not just little Santa Barbara County, South Coast. Did I?
Great introduction.
I insulted enough people. Judge Hill. Brian, how are you?
I'm very well. Nice to see you. Always nice to be here.
Yeah.
I love getting an invitation from you, and I love talking about constitutional law and criminal law in the courts.
Are you still teaching con law?
I am still teaching constitutional law. So I teach at
Santa Barbara Law School.
Santa Barbara College of Law.
Yeah. Well, that's why you're here. You're not just a judge that occasionally would throw me out of his courtroom, but you're a expert enough to be teaching young, what did Rush used to call them, heads full of mush.
Well, I tell you, it's very difficult to be an expert in constitutional law. It requires a huge amount of time and effort. I wouldn't call myself an expert, like there are some experts in the country. I mean, you see them on Fox, you see them on CNN, you see them on various talk shows, and these are people who devote their entire lives to studying the Constitution. And as you know, I'm a Superior Court judge. I hear cases by day, and then I try to study a little constitutional law at night. So I've done it a long enough period of time where I feel like I have a handle on it, but I can't hold myself out and wouldn't pretend to hold myself out as the kind of experts that we sometimes watch on TV.
I try and trick some of my friends from either side of the aisle about the best constitutional expert right now in the Senate was a Solicitor General for 8 years, and that's Ted Cruz. And people, he was Solicitor General of the United States. I said, yeah, back Bush, Reagan, and I do believe he's the best.
He's an impressive guy. I think he was a clerk on the U.S. Supreme Court.
Yep.
I don't know if it was either Thomas or Scalia, yeah. But to become a clerk like that, I mean, I think he went to Harvard Law, but to become a clerk like that, you have to have some special intellect, and he has that intellect, and you can see it. Whether you like his politics, don't like his politics, he's rational, he studies the Constitution, he studies the law. He's an impressive guy.
Yeah, it's unlike our president, who I think he turned the grading. Anyway, Ted was top in his class. Our president claimed to be, but really he was at the bottom. The only way he could be at the top was flip the chart.
The first time Biden ran for president, it was revealed that he had plagiarized while he was at law school at Syracuse, and he was basically forced to drop out. And he had represented that he was finished at the top of his class. He finished at the bottom of his class.
I think all of us could get trapped in plagiarism by not attributing what we're talking about to the source. But he took a whole speech from Kennick, the Prime Minister of England, and used it to get in his course to get a grade. Yeah, he's a piece of work.
Well, Biden, if you watch the Senate Judiciary Committee hearings, when I think maybe Bork and perhaps Scalia and others in the 80s and 90s, and he was the head of that committee, and you watch how he handled those committee hearings, it's night and day from the way he presents today.
Yeah.
I mean, you don't have to like his politics or dislike his politics, whatever, but he was very competent and capable.
Good
in how
staff.
well, a good staff, but I mean, he was for his position, given his perspective about the nominees, he did a pretty good job. Now, again, apart from politics, just in terms of competence. But I mean, I think all Americans have to be a little bit concerned about his cognitive decline, which is obvious. And I mean, for people to continue to say, well, he really is a smart guy, and he really is on top of the issues, and he presents very differently in private than he does in public, where he tends to stumble. I mean, we can all trust our eyes and our ears, and we know what we're seeing, and it's nothing against him. He just is in obvious decline, and to suggest that is not to just be playing politics.
It's almost sad what his wife and his handlers have done in pushing him into situations that are so embarrassing. And he, though, brought a term to politics and to the U.S. Senate in the hearings you were talking about. And the way he treated Justice Bork, it's now called borking, it's just to viciously attack the man who's being considered for any office. So we're going to talk about the Constitution, but I'd like to clear the table with some misconceptions that people come to me about the judicial system. For instance, somebody said they were recruiting people for the grand jury in Santa Barbara. And somebody said, well, geez, I might get stuck on a murder case. Explain the civil grand jury and
criminal grand jury.
Yeah, which is
and the way we initiate prosecutions in California. So
we don't have a sitting criminal grand jury, do we?
No, we don't have a sitting one, but let's talk about first civil grand juries.
Yeah.
So in the state of California, each county has the obligation to recruit volunteers to sit on what's called a civil grand jury. And I'm not going to be exact in the number, but it's somewhere probably between 16 and 24, something like that.
Yeah.
And so you'll see notices in News Hawk, and it used to be in the news press, and maybe on radio and TV, looking for volunteers to sit on a civil grand jury. And the civil grand jury responds to inquiries made by citizens regarding government operations. And so it acts as sort of a government watchdog group. And so if there's a complaint about, say, and this happens routinely, a complaint about mental health services in the county, or a complaint about jail overcrowding, which it's not such a big issue now that we have the North County Jail.
It was once.
But it was once. And so the civil grand jury will interview lots of people on those issues, and they'll issue a report. And the report is intended to inform both the public and the elected representatives about how government is doing with regard to certain types of issues, mental health issues, jail overcrowding, district attorney's office, how cases are being prosecuted, any number of things, but all having to do with government operations. Now, we have criminal grand juries.
Well, let me add something about the civil grand jury. When you were in high school, there was really an expose of our county jail, which, like the tower and the upper floors of the courthouse, I mean, murders were held up in some cells up in the tower, and the civil grand jury looked into it, and it's because of their report that the old jail, 40 years old, out off of Cali Real was built.
Oh, that's interesting. So in other words, what you're saying is that they can do good work, that they can bring attention to problems, and that the people and the elected representatives will respond, hopefully, if the reports have merit.
It's voluntary. I don't know if they get per diem or anything, but we in our Republican publication, The Wave, for 2 months earlier this year, all had one of our headlines was, volunteer for the civil grand jury.
Yeah, so we've had one for as long as I can remember, obviously, and I think it's pursuant to state law. It might even be the state constitution. But I would encourage anybody who has the time to volunteer to serve on the civil grand jury, because they do admirable work, and it's not easy. And on the pay, I don't think they get a per diem, but I think they do get the cost of transportation, so a certain amount per mile if they're coming from Santa Maria, where they live, and they're attending meetings in Santa Barbara. So they get some transportation costs. But you don't do civil grand jury work if you're looking to get rich. You do it because you have a sense of civic responsibility and you want to make a contribution to your community.
We had a gentleman who was on our central committee, retired, Albert Mikado, who was chairman of the grand jury for at least 2 terms, maybe 3. I think they sit for 2 years, and so.
So on the criminal side, we have grand juries. The authority to call grand jurors into session for criminal purposes rests with the district attorney. So the district attorney has a procedure. I knew it at one point. It also involves the presiding judge, and I was the presiding judge, so I was a little bit involved in the process. But basically, summons go out from the jury commissioner's office at the request of the district attorney. It's done sort of secretly. The criminal grand jurors are called into, usually again, a location that is not going to be noticeable to the general public because it's supposed to be done privately. And then the criminal grand jury will hear evidence that is presented by the district attorney. The defendant is not present. No defense attorney is present. And basically the grand jury is being asked to return an indictment.
Now, we don't use that very much.
We don't use it very much. We might use it in a case where, for example, a gang case where several of the gang members have decided to testify against other gang members, and you want to do it in a sort of private setting. You want to limit the possibility of retribution, of being labeled a snitch or a rat. So maybe in those circumstances, or it may be just a really complicated case involving multiple defendants, and so it just is more efficient.
Has there been any in the last few years?
Well, not that I recall.
So how are indictments, and how are they brought? So the police arrest somebody, the DA is indicting them. How is that brought into the justice system?
So the district attorney would initiate the process that results in jurors being summoned into court. They appear on a particular day. The district attorney is there. The district attorney has prepared a charging document, which is called an indictment. The district attorney has then subpoenaed witnesses. If it's necessary to subpoena the witnesses, most of the time it is. So then the witnesses come into the sort of the grand jury hearing room, wherever it is, and it's not open to the public, and it's not supposed to be disclosed to the public, so it's done privately. It's sort of secret. But it's secret not in order to prevent the public from knowing what's going on, but rather to generally, protect witnesses and also protect people who may be implicated in crime but not guilty of any crimes, whose names might be mentioned and talked about. So there's a variety of factors that might cause the district attorney to initiate the criminal prosecution by calling in a grand jury, preparing a charging document, calling the indictment, that we call in an indictment, and then presenting that indictment to the grand jurors The grand jurors are going to hear testimony. The testimony will be from only prosecution witnesses. The prosecution does have an obligation, in theory, to present exculpatory evidence to the grand jurors when they're asking for an indictment. But the grand jury will elect a foreperson, and they'll deliberate, and they'll decide whether to sign the indictment, which would then cause the case to be brought in front of a judge. So an indictment would be issued, say, by a grand jury, and then that indictment would be filed with the Superior Court. The presiding judge would direct that the case is going to be handled in a particular department. The district attorney might ask for an arrest warrant once the indictment is signed by the grand jury charging someone with a crime, and they might go out and arrest the defendant. They might also simply, in a given case, inform the defendant of the charges. Say it's a civil case in a prominent, not a civil case, but a nonviolent case involving maybe a businessman or a politician or something like that. There's ways to get the defendant into court without doing the formal arrest. And then he would be arraigned or told what the charges are.
So I don't have to worry about the police knocking on my door? The DA's going to call me?
No, you might have to worry about it. I mean, every case is different, so it's hard to generalize too much. But basically, it's a different way of initiating a criminal prosecution. And it doesn't happen much in Santa Barbara County or in any of the counties, because it's a little more complicated, because you have to summon in jurors. On the other hand, you don't have a defense attorney objecting to the questions that you're asking a witness.
The Constitution of the United States takes effect in what ways during this process?
Well, so the Constitution, I think it's in the Fifth Amendment, but could be the Sixth. But the Constitution directs that federal prosecutions are to be initiated through the grand jury process. So when Trump was indicted in Washington, D.C. by the prosecutor Jack Smith, that was done through the grand jury process. So a grand jury was summoned in, Jack Smith presented the evidence, there was no defense attorney, and the grand jury returned the indictment.
So
because that was on the federal side.
Donald Trump was a ham sandwich?
So
the old saying,
the old saw
yeah.
that the DA could indict a ham sandwich,
yeah.
And it's true, because you don't really have
No
opposition.
defense.
You have no defense. And there are certain rules that you have to follow. You can't present inadmissible evidence. You have an obligation to present exculpatory evidence.
You're not and I'm not a lawyer, I just cheat. You're not yet at that stage, even though you have a target, where the Brady laws come into effect, where you have to share, the prosecution has to share all information with the defendants yet.
Not at that point. At that point, none of it is shared, because it's all being done secretly. It's being done many times without the knowledge of the defendant. There's no one to share it with, because there hasn't been a charging document filed with the Superior Court. So that only happens after the grand jurors sign the indictment, which initiates the prosecution.
Well, the Constitution
Excuse me.
Gives several things having to do with that. It has, but one of them is the right to a jury trial. Now, how often do the attorneys con somebody into not having a jury trial, and why would they?
Well, I think both on the federal side and state courts, the system would grind to a halt if there were not plea bargains. So what's a plea bargain?
What's wrong with that?
Well, what's wrong with that? Yeah, that's a good point. So we could have that debate. That might be hours-long debate. But the point is that plea bargains encourage defendants to plead guilty, either to the charges that are set forth in either the complaint or the information or the indictment for some sort of reduced sentence. And so it can be beneficial to a defendant to enter into a plea bargain where he's pleading not to the charge count but to a reduced count.
Oh, so
In exchange
you
for the
answered
guilty.
my question. Frequently, the plea bargain isn't the same charges as were in the original charging.
Frequently.
Yeah.
Yeah, so you don't see much plea bargaining in the most serious cases. So you're not going to see a plea bargain in a first-degree murder case, typically, with premeditation and deliberation alleged, where there's a fair amount of evidence. So the district attorney is not going to be incentivized to reduce the charge to a voluntary manslaughter.
So this is all part of the guarantee of a jury trial. And how about the guarantee to confront your accusers?
Well, that's a trial right.
Yeah.
That's not a pretrial right. So that's not a right that exists, say, at the grand jury proceeding.
Who decided that? It's in the Constitution of the United States.
Well,
I think it's the Fifth Amendment or Fourth.
So the Supreme Court has said it's a trial right.
Okay.
It's not a right that exists at every stage of the criminal process. So we have preliminary hearings. So you can begin a prosecution by a grand jury that we've talked about in California, where you summons in jurors, or it can be the district attorney filing a complaint against the defendant, and then the defendant has a right to a preliminary hearing. So even at that preliminary hearing, which is preliminary to a trial, certain hearsay evidence is admissible. And so there's not necessarily a right to confront your accuser at the preliminary hearing stage. So the Supreme Court has said that's constitutional. The preliminary hearing is just preliminary, it's not the trial.
This is where, outside of a grand jury, this is where the prosecution presents the evidence for an indictment. At that point, does the defendant have rights?
So, there's a defendant has rights, but if the indictment is, if the district attorney has opted to go by way of an indictment in grand jury, the defendant has his confrontation rights at the trial, and not before.
So now we have a right to, from the U.S. Constitution, we're talking about it today, to a jury of our peers. Where are they going to get people with 180 IQ? I mean, come on, that's not. I mean,
in other words, you
much.
Cannot be prosecuted because there are no peers
yeah,
for you.
Exactly. It's not that high. Close. No, and so the jury selection, we've heard terms because of the Trump cases, but other prominent cases, change of venue. Okay, how does that work in your court?
So a defense attorney would file a motion to change venue. There's a lot of law on the circumstances under which venue should be changed. Usually it has to do with a lot of pretrial publicity in a particular community.
It's back to that right to a jury in the Constitution.
Right. So the change of venue cases have come up where generally it's a very gruesome and inflammatory kind of crime, usually a murder or multiple murders in a small community. Everybody is familiar with the crime. They may know the defendant, they may know the victims, and so it's hard to find 12 people who don't know the defendant, don't know the victims, don't know the witnesses, and that occurs in small communities. And so change of venue would be more likely to be granted in that circumstance than even a community the size of Santa Barbara. It would have to be pretty pervasive publicity. And so what's the danger with pervasive publicity? Well, it's that the jurors are going to learn stuff about the case that is not stuff that is presented during the trial. And so they may base a decision, guilty or not guilty,
rumors.
on stuff that they hear outside the courtroom.
Okay, you've had change of venues. Are you restricted to changing the venue only within the county of Santa Barbara, or can you send it to Bakersfield?
So when we grant a motion to change venue, you're testing my memory, but I think we go to the Judicial Council and we ask for an assignment where the case will be heard. So in the Smart case, Kristen Smart out of San Luis Obispo, the court granted a change of venue and then went to the Judicial Council, and they assigned the case to Monterey County, and the case was heard in Monterey County,
Well,
in front of a judge from
that's
Monterey.
the girl who disappeared. There were signs all over for 25 years.
For a long time, yeah.
Then they
And they finally gathered enough evidence, maybe there was some DNA evidence that wasn't available at the time, but ended up prosecuting the case after a motion to change venue was granted up in Monterey.
And he was found guilty, and his father, I think, was found guilty of obstruction.
Or accessory, one or the other, yeah.
So we've got that silly Constitution saying a jury. Why would anyone ever submit to you and not 12 of my peers?
Well,
And that pertains
And I've had a couple-
civil cases too, doesn't it?
it pertains to most civil cases. There are some civil cases where you don't have a right to a jury, family law cases and I think probate cases, but I'm not 100% certain, which cases on the civil side where you're not entitled to a jury, but I know family law you're not. But why would someone waive jury?
Yeah.
Well, because it might be the case that you believe that the judge that you've been assigned to is favorably disposed for whatever reason to the kind of arguments you're going to be making in front of the judge. You might understand that the case is more about sentencing than about guilt or innocence, and you might want to proceed, to the sentencing phase, and so for that reason, you might even plead guilty, open to the court, and just have a sentencing hearing in which there might be a lot less testimony presented about a inflammatory, gruesome, heinous crime. And so then
sentencing is almost always the judge. When and how would a jury?
Sentencing is always the judge, except in a death penalty.
Okay,
case.
that's where you have a.
That's
a
where
dual,
the jury.
The same jury found him guilty, then you reconvene for the penalty phase.
Exactly.
And does the judge get to, at any point, have you ever ruled the jury wrong and entered a judicial decision?
So we haven't had many death penalty cases. Newsom's put a moratorium on the death sentence, on the death penalty. So everybody on death row in California is just in a sort of holding pattern. So I've had 2 death penalty cases. I had Jesse James Hollywood, where the jury returned life without possibility of parole. And then I had a guy named Joshua Martin Miracle. The jury returned a death verdict. And your question, I think, is, does the judge have the authority to impose LWOP where the jury has decided that death is the appropriate sentence?
Yeah.
I don't know the answer to that. But the converse is definitely not the case. So if the jury returned a penalty verdict of life without possibility of parole, the judge in California can't impose death, and I think that's a national rule. So whether it's works the other way, I just don't know the answer.
In one of your prominent criminal cases. Recently, a man butchered a man, his wife, and child.
2 children.
Say again?
Oh, when you say butchered, I had one case which was a quadruple murder involving a knife. So when you say butcher,
Yeah.
then I had a triple homicide case
In the
involving
garage?
a gun. Yes, involving gunshots.
Yeah.
So
Just-
2 separate cases, but
Just a partnership disagreement that they didn't trust the judge to.
well, I think if you're a criminal defendant, it makes some sense to put the case in front of 12 jurors because you only need one that decides that you're not guilty or can't decide the case.
In the new era of AI, do you anticipate and have you begun to see people in civil cases want to go before a judge, not a jury of people who aren't going to understand the.
Well, I haven't really thought about it. So,
It's so new.
yeah. So you're talking. I think what you're saying is that in some of these cases, the technical issues are difficult to comprehend and understand.
Right.
And trying to explain them to 12 people from the community, many of whom won't have those kind of backgrounds, might be difficult. And it might be a lot easier to get your point across on these more technical issues with regard to just a single judge, who may have more time to devote to trying to understand the issues. I think that's a fair point. I haven't really thought about it. I haven't seen that.
Well, in my lifetime, the judiciary has changed. When I first was in business, there was a court, a justice court, and in fact, a friend of mine who was DA, Dave Manier, said the greatest person sitting in the justice court is a milkman in Lompoc. And you didn't even have to be an attorney to sit as a judge in the justice court. First time I saw Judge Lodge, he was justice court in Goleta. We talked off camera about Rick Brown in Santa Ynez. He was a justice court judge. That evolved in them blending those into the municipal court.
Yes.
So there are 2 tiers. When did they do away with it and just only Superior Court?
So that happened, I think, in about 1998, somewhere around there, where we had a sort of reorganization of the courts. So we used to have justice courts, we used to have municipal courts, and then we had our superior courts. So reorganization was affected in, I'm going to say 1998 or so. So now we just have a superior court. And that made some sense because we had municipal court judges that were limited to hearing preliminary hearings and misdemeanors. And then you had superior court judges that would only hear felonies and more serious civil cases. And so at any given point in time, you might have municipal court judges not doing anything, just having free time, and superior court judges being overwhelmed. And so in terms of a more efficient use of resources, and judicial resources specifically, the legislature, I think, made a wise decision to reorganize the court so that whether we're all superior court judges, and so we all hear all types of cases, from traffic court type cases, speeding, infractions, all the way up to the most serious civil and criminal cases.
There are still, as I understand it, 2 courts in Santa Barbara. There's the municipal court.
No, we don't have municipal court anymore. So
Superior Court, yeah.
We just have superior court.
And then you have small claims court.
Well, but those small claims actions are typically heard by superior court judges. Now, in some counties, they've attempted to recruit people from the civil bar to sit as judges in small claims actions.
They were
as long as
doing-
you get I think you have to get a stipulation or agreement between the
They
parties.
were doing that the last time I was in small claims here.
You had an attorney.
Yeah.
Yeah.
I would immediately say I want a regular judge, because I wouldn't sign a stipulation. That drove them crazy, and it also threw it off for a day or two, making whoever I was, usually college students, just fighting over rent deposits. And so I would demand a Superior Court judge, and then frequently none's available till next week, but we're going home.
Well, I think the better practice is to have a Superior Court judge handling those small claims actions, because the kinds of issues that you address in small claims actions are the same kinds of issues that you would address in a serious civil case. You have evidentiary issues, you're dealing with breach of contract, you have to know the elements of a contract.
I never
and all the rest.
had a case before you, but Tom Anderley, Judge Anderley, and I think Judge Tim McMahon years ago, both heard cases I was involved in. Both had to give a disclaimer about how they knew me and give the other side the right to. And in all cases, they didn't want to come back, so they waived their right to a fair judge. And the judges would say, "Now, I've known Jim since Anderley used to say, I know him to be an honest man, and I have no doubt, but I think I can rule." And he ruled against me 1 out of 3 times.
So he's very fair, and he has that reputation.
Yeah.
So
I told him it was wrong afterwards.
and he didn't care.
No.
No. He's going to do what he thinks is right, which is what you want a good judge to do.
I'll tell you a story about my daytimer, which I use in testimony and expert witness. I've been admitted as an expert witness in restaurants and real estate in both Santa Barbara and Ventura County. And I'll tell you a story about it someday, because he loved that I had written down on day 5 of year 20 everything that had happened by the hour. And so through all this, a attorney has a right, a defendant has a right to an attorney.
Yes.
They didn't always, did they?
Well, there was a case decided, I think, in like 1966.
Miranda.
Well, not Miranda, but Gideon versus Wainwright,
Okay.
that basically said that a criminal defendant in a misdemeanor or a felony case has a absolute constitutional right to an attorney. If they can't afford an attorney, one will be appointed for them. So.
And that's when it was codified, every police officer carrying it, and then it's
so
the
that's
Miranda
Miranda.
right.
That's Miranda, so that's different. So
Yeah.
you have a right to an attorney, but you also have your Miranda rights when you're arrested and the cops want to talk to you, that they have to advise you of the so-called Miranda rights. You have
Yeah.
a right to an attorney to be present during questioning. You have a right to remain silent. If you want an attorney appointed, one will be appointed for you. Understanding these rights, do you wish to talk? Yes or no? So it's not verbatim, but it's the gist of it.
We've got the jury, we've got the defendant's rights. How frequently do you have a renegade juror, such as myself, who says, "I don't believe in that law"?
You have that. You try to address it in voir dire, the portion of the jury trial process where you question the jurors. You ask them, are you prepared to follow the law? Even if you disagree with the law, the DA takes the lead on that usually in terms of questioning the jurors. But does it happen? Sure, it happens. It happens where you have a juror who's just not prepared to follow the law. 11 other jurors think the case, in terms of the evidence, was overwhelming, and you have one holdout juror, and then you just end up, trying the case again. Typically, on the second time around, you'll get a guilty verdict. But it can happen the other way. I think it's less frequently, but it can happen the other way where 11 think where 11 think he's not guilty and one insists he's guilty and will not move from that position. So that's our jury system. You have to have 12.
Well, the extreme case, I think, and I'll ask you if you've ever seen it happen or thought it happened, jury nullification.
I've seen it happen.
Explain that.
So jury nullification is where the evidence is overwhelming. I mean, I think we saw it in the O.J. Simpson case. The evidence is overwhelming, but for reasons unrelated to guilt or innocence, the jury is uncomfortable with returning a guilty verdict. Uncomfortable is a polite way of putting it. It's a kind of a euphemism. Sometimes it's because they're uncomfortable. Sometimes it's because I think they want to make a larger point. So I think there was people have different views about Simpson, but I think there was a sense that there may have been some shenanigans by the police officers. Whether there were or not, I don't know. But I think there was that sense, and so the jury was a little offended by police officers who were perhaps not being 100% forthright. I've had a jury nullification case involving a murder prosecution against a 15-year-old back in the day when the district attorney had the unreviewable discretion to file murder charges against juveniles in adult court. And there was a videotape that was presented at the trial showing the 15-year-old stabbing a 14-year-old. And so the evidence was overwhelming, but the 15-year-old defendant in adult court looked like he was about 10. And I think the jury struggled with that. And even during voir dire, it was difficult to find 12 people who were prepared to find the defendant guilty, even if the evidence showed beyond a reasonable doubt he was guilty. We did get 12, and we had 12 represent that on the record, but the jury hung. And I think the DA recognized also the difficulty in prosecuting someone in adult court who just didn't look like he belonged in adult court, regardless of the nature of the crime. And so I would say that was the most odd, in my view. Maybe people who were present, watched the trial, have a different perspective, but in my view, that was an example of jury nullification.
Yeah.
And somewhat understandable, I mean, it doesn't mean that he goes free, doesn't mean that he's not going to be punished. It's just difficult for the jury to view him as incorrigible, unredeemable, subject to a 25 to life sentence at the age of 15.
The right to privacy, Constitution again, a judge makes a decision when a prosecutor asks for a search warrant. The defendant has no right to oppose that search warrant. It's going to be executed. Then they can argue about the admissible of the evidence.
Yeah, so you're absolutely right. So the cops prepare the warrant. They have to describe with specificity the area they want to search and what they're looking for. They have to provide an affidavit or a declaration under penalty of perjury why they think the evidence that they're looking for will be found in a particular location. Then that's presented to a judge. The defense is not there at that time. It's just the judge reviewing the declaration. Judge signs, let's assume the judge signs the warrant. The cops didn't get it. They execute the warrant. Let's say it's on a defendant's house, and they search the house. And and then let's say they find incriminating evidence, and so on the basis of that incriminating evidence, such as say it's drugs, the defendant is arrested and he's brought before the court. And at that point when he's brought before the court, his defense attorney can file a motion to suppress evidence, alleging that there was not, for example, probable cause for the judge to have issued the warrant, or there were other sort of defects in the actual warrant. There wasn't sufficient specificity in describing the place to be searched or the items to be, looked for. So it could be any number of things. I mean, in terms of, there's a whole big body of law on suppressions. But it's a motion to suppress, and then it's going to be heard before a judge.
Does the Constitutional speak to the right of a person to have his attorney or expert's documents privileged and private?
Or what do you mean? I'm not sure I'm following.
Well, for instance, President Trump's attorney testified against him in court, and the judge allowed broad testimony, even though the guy was serving time for being a perjurer in federal court.
You're not talking about the most recent convictions?
Yeah.
Oh, you are?
Yeah.
Oh, so Cohen testified?
Yeah.
So
how can that be? He's my attorney.
But a lot of this was public record,
Yeah.
so it wasn't a privileged conversation, and so and a lot of it was done by Cohen himself, and so Cohen. I don't know that I followed the case in terms of every bit of evidence, but Cohen allegedly directed that these payments to Stormy Daniels be characterized as legal services, legal services. And then the question was, did Trump know that?
Yeah.
And I don't think...
Well, it went a step further, and I don't know how this fits in the Constitution. He directed it under a non-disclosure agreement. Now, does the Constitution apply to a contract to non-disclose actions?
No, typically non-disclosure agreements are extremely commonplace.
Yeah.
Okay, they're signed by lots and lots of people, ex-employees. They're signed by people who are, in the Stormy Daniels situation. I think Clinton paid off a couple of his ex-girlfriends. They signed non-disclosure
7 or 8.
agreements, a fair number. So it's pretty common, and there's nothing illegal about it. So the New York case was interesting because it was I think it was under New York law false statements. That was but they have to be false statements in relation to another crime. So the allegation was that Trump knew that these payments to Stormy Daniels that were characterized by Cohen as legal services were related to some other crime. And so then the question was, well, what was the other crime? And the prosecution put forth 3 other possible crimes, which I don't think were defined for the jury. One was campaign finance, one
misdemeanors,
one was campaign finance law, one was violation, one was, I think, some kind of a tax fraud because he was trying to maybe take a deduction for legal services, and the third one I can't recall. But
the third one I don't think anybody knows because it was given to the jury
so late.
The last minute to make the case felony.
So the interesting thing about that is the jury was instructed that with regard to these allegedly false statements, which were the payments to Stormy Daniels, characterized as legal services, okay? They weren't legal services, they were payments. That would have been a misdemeanor unless you can say those false statements related to some other crime, which is a felony. So the jury was told that they don't have to agree on which felony these false statements related to. So 4 could agree that there was a campaign finance violation, 4 could agree it was an income tax violation, and 4 could agree something else. Well, I've never heard of that. So let me give you an analogy that I actually thought about just this afternoon. So we have criminal cases where the prosecution will allege, the people will allege that the defendant committed the crime of, say, residential burglary. And then they'll also allege that the defendant has 2 prior convictions, which are strikes, which would increase the penalty for the residential burglary if the defendant is found guilty. Well, the allegation of having suffered prior convictions, which we call strikes in California, will cause the residential burglary sentence to be increased, as I mentioned. The defendant has a right for the jury to decide whether those allegations of, let's just say hypothetically, 2 prior strike convictions have been proven beyond a reasonable doubt. Now, the jury has to all agree that each of the individual strikes, or one or the other, or both, have been proven beyond a reasonable doubt.
That's the previous cases.
Yeah, previous cases. The jury can't say, well, the jury is not instructed, well, if 6 of you believe that defendant suffered 1 prior conviction, and 6 of you believe he suffered a 2nd prior conviction, then that's 12, and so then we can enhance the penalty because all 12 have agreed he suffered some prior conviction. You can't all agree on which prior conviction. Well, that's unheard of. That's a violation of due process. That's a violation of your right to the jury to decide each and every element of the charges that have been brought. And so that's sort of analogous to what happened in the Trump case. In the Trump case, the jury wasn't told, all 12 of you have to agree that the defendant committed this campaign finance violation in order to convict him of this false records charge. They were told, well, if 4 of you think that he committed a campaign finance law violation, if 4 of you think he committed the income tax violation, and 4 of you think that's enough. Altogether, that's 12, even though 12 people haven't all agreed unanimously that he committed one of the predicate offenses, whatever they were alleged.
A lot of appeals.
So that's unheard of. That's going to be a reversal. I can't imagine that wouldn't be a basis for reversing the conviction. But it's politics. I think any reasonable, rational, objective person would understand that the charges were brought for political reasons and not for other reasons, because these charges were rejected by the Department of Justice. They were panned by the New York Times and by the previous DA who rejected bringing the charges.
Lowenthal,
So, it was pretty political.
So we're coming down to the last few minutes. We have an election coming up. In many areas, the Republicans and Democrats recruit attorneys to be poll watchers. Where is there a problem and an attorney goes in and tells the head of the poll, the people who are taking the votes and counting them and putting them away to count, I'm an attorney and I'm here watching what you're doing?
Well, is there a problem with that? Well, potentially there is. These are the procedures that are put into place to ensure that the people are not threatened or intimidated when they go to the polls, that they're not going to be badgered when they go to the polls, they're not going to be cajoled or bribed when they go to the polls. And so I think it's appropriate to have people observing the manner in which the government is operating their elections. Those would be the poll watchers, whether it's attorneys or anybody else. I think that's fine. But you have to be careful that you're not inviting any sort of indirect intimidation or implied intimidation. We have these rules that you can't, if people are in line to vote, which shouldn't happen, by the way, right? I mean, you shouldn't have to wait 2 hours to vote. That's ridiculous. And so that's the underlying issue that really needs to be addressed. But one of the concerns that was raised was that people were approaching those folks who were in line on a hot day when they were waiting to vote and giving them to water. Well, we have rules against that. Now, we don't have rules against people bringing their own water. We don't have rules against people drinking water. But we do have rules against people coming up and saying, here's a gift certificate to, Ralph Lauren, or here's, and by the way, let me just chat with you about. And so we have these rules that are designed to ensure that people are not being badgered under the pretense of we're giving you water or we're giving you a drink or a candy bar or whatever. Nobody cares about whether somebody is drinking water. They can bring their own water, but the idea is we don't want people from both sides. I mean, this is not a Republican Democrat. We don't want now Republicans coming up to people and saying, "Oh, you got a one Milky Way. I'm going to give you 2 Mars bars." Yeah. But I also want to chat with you about your vote and because nobody's monitoring these conversations with people who are in line to vote, and so there is an understandable reason, because there have been abuses, why you would have a rule that says that random people can't come up and start giving you stuff, and then have the opportunity to kind of twist your arm or to make a last-minute pitch to vote for one side or the other and say whatever else you're going to say. Now, if it's a problem, have the government provide cases of water and address it in a nonpartisan way.
As long as it doesn't say President Biden on the government water.
Vote for Trump, vote for Biden, come to Harry's afterward, free drinks for everyone who votes for Trump or Biden. So it's nonpartisan, but the idea is...
Trump has an opponent?
He does. He's got a lot of them out there. Yeah. There's been 4 prosecutions